Well, I'm now joined by Mava Scott, who is spokesman for the Competition Commission. We've talked this week about the allegations about Group Five's collusive tendering. Good morning to you, Mava.
Morning, David, and thanks for having us.
This cloud that is over the construction industry just won't get blown away, will it?
It's taken time. You will recall that it dates back from 2009. 2011, we invited all of them to come and confess their sins, if I may put it like that. A few of them came forward, but there were those who did not come. But there were cases that were settled during the phase one settlement period, but there were outstanding ones as well. So we are busy with phase two, where we are following up on those who did not settle on phase one. We are also dealing with those who never even came forward during phase one.
Now, there's a point up there from Group Five, the company that we're talking about this morning. Group Five's lawyers have advised there are evidentiary hurdles in the Commission's case in the respect of two referred products, and the group has good prospects of opposing the Commission's referral of the matters. So they've clearly not come forward and confessed sins because they don't think the sins are there, or certainly not what you think they are.
Certainly, they did not even come to the phase one to confess anything or involvement in the collusive bidding. But we've got enough evidence to prove that there was a contravention of the Act. Hence, we have referred the matter for adjudication at the tribunal. So if they believe that they've got a story to tell, or they are clean, as they claim to be, let's meet at the tribunal, let's adjudicate the matter and see how far it goes.
I mean, obviously these things are complicated, but is it possible for you and they to be so far apart? Can't you get together and kind of resolve this and maybe come to a compromise?
We made a call initially in 2011 that firms should come forward, all of them, to come and confess their sins or reveal what activities they were involved in.
But in like return for amnesty.
Yes, like a tax amnesty, in return for a discounted administrative penalty. So some did come and we resolved the issues. Those who did not come can't now during phase two say, look, we can come and talk and negotiate and so on. But we are saying, as the Commission, we are still open to that. This particular case, unfortunately, has reached a particular stage where we have now taken a decision to refer to the tribunal for adjudication. We believe we have enough evidence to prosecute, and we have just we've done just that.
One of our commentators, Mike Howarth, who comes in the studio regularly, he said you've got to be careful with the construction industry. If you hammer it too hard, they're not going to invest, and maybe when we need them to be investing and to expanding their business, they're not available when the economy picks up. Is it possible that you've come down too hard on the construction sector? Not so much in looking for collusive activity, but in the fines and the uncertainty that still hangs over it.
It's interesting that other people are saying that the administrative penalties we are imposing are too lenient. The maximum being 10% of the annual turnover. People are saying we are lenient. I mean, the harm that has been caused by collusive conduct over many years has been very huge. Others are saying, like you are now telling me, that we are coming very, very heavily on them.
Well, I'm quoting one of our...
Yes, the issue is that competition is good for the economy. Competition is good for business. If you allow such conduct or cartel conduct to continue in an economy, it forecloses other businesses. I mean, people want to come in and invest into the construction industry. And if you've got big guns who have foreclosed that kind of environment, it's going to be difficult for new players to come in and invest in the economy.
It's not my view, I'm just quoting a view.
Yes, I'm just saying that, I mean, there's pros and cons to that.
And we saw it in other industries as well, like retail and the Tiger Brands collusion in the Western Cape. So when will the cloud over the industry, in other words, when will you settle all these cases, whether you're finding them or not? When are we going to have it sorted out?
We are now in the final stages of our phase two. In fact, we are left with about 2 cases that we are now investigating finally. In the initial phase, we had 15 coming forward and we settled with them. We were left with 24. We are now left with only 2 that we're investigating. And, well, we can't predict how long litigation is going to take place.
That gives us the picture. That is Mava Scott, spokesman for the Competition Commission. Interesting stuff there on the Group 5 case and the broader issues over construction.